strap in, because this sentencing hearing is not what you think. The defendant has already taken a no-contest plea to count 2, and the state agreed to be silent on punishment translation. The prosecutor won't argue for a number, but the judge still holds all the power. The defense wants mercy and deferred adjudication, a path that could keep a conviction off her record if she follows strict conditions. But there's a problem brewing. The court has her criminal history, and we're about to hear admissions about recent drug use, a scale in her purse, and lab-confirmed methamphetamine weights that raise serious red flags. At stake, freedom versus prison, outpatient help versus inpatient custody, parenting time versus protection orders, and whether the judge sees an overwhelmed mom who needs treatment or a heavy user whose facts don't add up. Watch every pause and correction. Credibility is everything in sentencing. Question for you as we roll. If a defendant admits they'll test positive today, should that push a judge toward rehab or toward prison for accountability? Stay with me. The ruling comes fast, the legal reasoning is sharp, and the consequences are very real. Let's break down each move, explain the terms, and call out the pressure points the judge simply cannot ignore.
All right, we're here for sentencing today. According to the plea bargain agreement, she pled no contest to count 2 of the indictment. She applied for deferred adjudication. The state is proceeding only on count 2 according to the plea bargain agreement. Punishment is to be assessed at 6 years in the prison, and the state is silent on the defendant's application. The court requested that the defendant's criminal history be provided to the court. There were no objections to the court receiving that from the state. Is that correct?
Correct.
And any objections to the court reviewing that?
No, Judge, of course not.
Right. Thank you, state. All right, the state is silent. Is there any?
We open with a classic tension. Defense asks for deferred adjudication plus outpatient treatment, emphasizing the client's self-employment, customers, and kids. Smart advocacy: humanize your client, show community ties, and propose treatment. But here's the catch. The judge controls sentencing, not the plea terms. And state is silent doesn't mean state is supportive. Judges weigh public safety, prior history, candor, and whether a plan is credible. Outpatient can be appropriate for low-risk, compliant defendants. It's tougher to sell when the court anticipates a positive drug test today. Engagement check. If you were the judge, would the request for outpatient feel realistic or naive given what's coming next? Keep your eye on how the judge tests inconsistencies, because credibility, not sympathy, will drive this outcome.
Anything you wish to say on behalf of your client?
Judge, of course, Ms. Torres is hoping you'll grant her application for deferred. She's in self-employed cleaning houses. She has several customers that rely on her. She has a few kids. She's just asking for the court to maybe direct her to some outpatient treatment because she believes she needs some help with this problem. And other than that, again, she's just hoping you'll grant her application.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Missy Ann Torres.
All right, so.
Huge moment. The defendant predicts a positive meth test today and frames use as driven. Legally, that admission matters. Sentencing courts consider post-plea conduct and using illicit drugs on the eve of sentencing screams risk and lack of control. Also listen to her phrasing. I don't do it around my children. I don't do it every day. Mitigating, maybe, but it still signals active use, which undermines the defense's outpatient pitch. From a treatment lens, honesty is good. From a sentencing lens, active use today narrows the judge's options. Question for you. Does honesty about a relapse earn credit, or does timing erase that credit because it shows poor judgment?
You're going to get drug tested today. What are the results going to be?
They will come back positive.
Positive for what?
Methamphetamine.
All right. So how often are you using meth?
I only do it when I'm under stress, and I did it because I could get denied for adjudication, so
I'm sorry, what?
I could get denied the application, so I was kind of I just do it when I'm under stress. So I know I have a problem and I don't do it like around my children. I don't do it, you know, every day. It's just, when I'm under stress and I was, really scared. So, and really under stress. So I don't do it when I go to work. I don't do it, every day, like I said.
All right, so how many children do you have?
I have three,
What are their ages?
11, 8, and 5.
The children issue gets complicated fast. She first says where the kids are, then revises to explain she lives with her grandmother who helps with care. The judge immediately flags unsuitability of two things: cleaning houses given the offense, and caring for children right now. Why judges must weigh child safety and public trust, especially when active drug use is admitted. Mixed statements about living arrangements and care can sound like minimization even if she's trying to explain. For viewers, unstable facts plus active use equals reduced confidence in outpatient supervision. Engagement. Do you hear a struggling parent? Trying to stabilize our pattern of rationalization that makes in-home care unsafe.
And where are they now?
Two of them are with their dad and one is with my grandma.
All right. With your grandmother, so their great grandmother?
Yes, ma'am.
All right. So, do you help take care of your children?
Yes.
How
I-
often?
I see them every other weekend and I don't pay child support, but I pay them. My exes and I have my daughter. My daughter is with me.
No, you just said your daughter is with the
Yeah,
great
but I
grandmother.
live with my grandmother. This is it.
All right.
So I help take care of her. She
All right.
helps me take care of her.
Okay. So one, I don't think it's appropriate for you to be cleaning houses
Okay.
because of the nature of this offense. And two, I don't think it's appropriate for you right now to be taking care of your children.
That's why I'm asking for help, Your Honor.
I'm sorry, what?
That's why I was asking for help, Your Honor. That's why.
All right.
The judge draws a bright line. Custody today, if deferred, is granted. That's a pivotal constraint many people miss. Deferred adjudication can include strict conditions, starting with immediate custody for evaluation or placement where sobriety is in question. This preempts further risk in the community and stabilizes the defendant for meaningful treatment. The defense asked for outpatient. The judge signals that's off the table. This isn't just punitive. It's about containment and compliance when there's fresh use. Legal takeaway. Judges may combine leniency mechanisms with short-term custody to protect the public and set a firm structure. Would you accept short-term custody if it improves your odds of long-term probation?
Your help is not going to be outpatient treatment if I grant this application for deferred adjudication. So you're going into custody today.
Okay.
All right. So it's just a matter of what I'm going to do with you. I will tell you the court's issue, and if you want to address this, I know the state is proceeding on count 2 of possession, but she had a lot of drugs with her.
No.
So I don't understand, if you're working homes, then why do you have a scale?
Now the evidence profile. A scale in the purse, baggies, and weight totals that far exceed casual use. Even though the state proceeded on possession, judges can consider the circumstances surrounding the offense in sentencing. A scale suggests measurement. Baggies suggest portioning facts that can support an inference of distribution even when the charge is possession. The defendant insists it's all personal use, but the court is allowed to consider common sense indicators. Key concept: charge selection does not equal fact vacuum at sentencing. The lab weight and how it's packaged drives the judge's risk assessment. Does the scale feel like protection against being shorted, or does it cross a line in your mind toward intent?
With you, because that's, according to this, you had drugs, you had a scale in your purse, and there were baggies totaling 32.0 grams.
Well, Your Honor, I was a heavy user back then, and it was.
Oh, you're not, I tell you what, I don't think, and if I'm wrong, correct me, I don't think you were using 32 grams of meth.
It was only 28.
No, you have meth here for 4.964 grams, and you also have meth for 27.459 grams. And what you pled to in count 2 was a possession 4 to 200 grams. So this is not a possession 1 to 4. So we're talking about 27 grams. And according to the stipulations, that what was found in your bag, it says, I searched her bag and inside a Paris Hilton makeup bag box were baggies, a scale, and crystal-like substance inside a cut vacuum sealed bag. That's from your Paris Hilton makeup bag.
So the
Excellent judicial clarification. Field tests and field weights aren't the legal anchor lab results are. The judge focuses on 27.459 grams net from the Paris Hilton bag and separates that from another person's 6.12 grams. This precision matters. By situating the weight in the 4 to 200 grams band for count 2, the judge frames punishment exposure without inflating numbers. Defense often attacks field testing. Here, the court already discounts it and still lands on a concerning lab-confirmed total translation for viewers. The court is giving the defendant the fairest reading of the science and it's still bad. Question: does the judge's careful reliance on lab data increase your confidence in the fairness of the process?
what I had, the meth was it was double bagged in a sandwich bag. So yes, ma'am, I know it was 20, but it's because that was my personal. I didn't have any other. And last time I went, they tried to only give me which was 14 grams. So I had to.
No, what I'm telling you is, they said the baggie found in Robert's pocket tested positive for meth and had a field weight of 6.12 grams.
That wasn't mine.
No. I'm not saying that was yours. So the 6.12 grams that were found in his pocket, they're saying that was his. It was in his pocket. But the baggie, which was found in Missy's purse, tested positive for meth and had a field weight of 32.09 grams. Now, mind you, what they do in the field, I already know that testing drugs in the field are not legal for court. So I'm not considering the weight and what they said in the field. I'm considering what has been given to me for laboratory reports. So this was the professionals testing it, not a presumptive. And it says 27.459 grams was the net weight of the meth that you had in your Paris Hilton bag.
Yes, Your Honor. And I will.
The defendant volunteers details, an ounce in 2 to 3 days, price at $250. Double bagged a personal scale to avoid being gypped. Honesty helps in treatment court. In sentencing, these facts can aggravate. Why? They suggest extreme tolerance, resource commitment, and drug-focused routines inconsistent with safe parenting or trustworthy employment in private homes. The judge invites transparency, but transparency here corroborates volume and planning, not impulsive mind grooves. Defense wants treatment, and the judge may agree treatment is necessary. The dispute is where treatment starts inside or outside. Custody, engagement. Do these admissions read as accountability or as confirmation that community supervision is too risky right now?
Say that I used to use a whole ounce within 2 to 3 days. So I was a heavy user. And like I said, they tried to give me half of that the last time. And right now it's going for $250. So if I'm paying $250, I wanted the whole thing. I wanted to make sure. I'm just being honest, and I'm sorry. Excuse me for being.
No, I want you to be honest and I want you to be transparent.
I'm sorry for being transparent, but it's something that I feel like I worked for my money, and I didn't want just to get gypped again. I can promise you I didn't sell anything. It was because I've been gypped many times. So I did get it. Now it was double bagged because I don't know, that's the way they gave it to me. I can't, and it is my mistake and I'm taking full responsibility, but I wasn't selling drugs. I didn't have a job. And back then I was, a heavy user where I would just do it before work, after work, and I didn't have my children in my life. Now I do have my children back in my life, and I'm trying to be a good mom. So I thank you for, giving me an inpatient program.
Crucial pivot. The judge says she's not walking out today. It's either prison or inpatient treatment. Why frame it this way? Because the packaging, weight, and fresh use collapse the feasibility of outpatient compliance. The judge emphasizes truthfulness as the only currency that might keep her out of straight prison. This is classic judicial leverage. be fully candid, accept structure, and maybe earn a treatment-centered placement. Note how the court distinguishes punishment from clinical need. You can have both. Viewer question: if you were advising her, would you push for inpatient immediately to show commitment, or roll the dice, arguing prison is excessive, given the plea?
Well, no, I'm not saying I'm going to give you
Oh, I'm
inpatient.
sorry.
What I'm saying is that you're not walking out of this courtroom today. Either you're going to be going to prison or either you're going to be going to inpatient treatment. So it's very important that you be 100% honest with me, because I'm telling you, the state proceeded on a possession, but the amount of drugs you had and the way they were packaged, that's concerning for the court. So you're saying that you just bought a bunch of meth and you were saving it up for use?
So I would use within 2 to 3 days, that was all my personal. Like I said, they tried to sell me half of that one time, and I went back to the same person, but I said, I'm gonna weigh it myself to make sure I'm getting the right amount, because I'm an addict. I'm sorry, I am. And we're not.
So you travel with your own scale?
Well, at the time I did, because like I said, I've been gypped, and when you're an addict, that's all you think of, just how to get, make sure you're getting what you need. And honestly, I can see where I made my mistake, but I'm being honest with you. It was my skeleton measure. So my personal, that's it. And I don't know if Robert would tell you that was my personal as well. Like, I mean, I don't want to call him or anything, you can if you want to. But he would tell you that's why I used to pick
Oh, no, I'm not going to be calling Robert, because Robert probably has a case of his own.
Right. But I'm saying Robert can tell you too, within 3 days, maybe 2 to 3 days, really, it would have been gone, and I would have been back doing it again. Now I don't. It was kind of like a stress thing. And
Where did you?
Another powerful fact, she says she used on Saturday, anticipating court. Defense quickly reframes: active use signals a serious addiction requiring rehab, not retribution. It's a smart pivot. Convert bad facts into clinical urgency. Some judges bite, others see it as proof of noncompliance risk, even under court pressure. The defense also signals flexibility. If treatment must be an ISF, SAF, PTC, they'll accept it. Strategy note: when facts are rough, own the problem and propose a structure that protects the public while treating the person. Engagement does. Pre-sentencing use make you more sympathetic because addiction is powerful, or more concerned because court orders didn't deter her.
You get your drugs to use today before you came to court?
Just an old friend. I hadn't talked to him since, and it was on Saturday when I knew it was, coming, and I guess I felt, under pressure.
If
Yes.
I'd like to say something, I think the fact that she would actually go out and do the same drugs that she's about to get sentenced for in a couple of days, I think really speaks to the fact that she has a serious addiction problem that I think only rehab can treat. And if you decide that's ISF or SATF or SAFP, we understand that, but I think she really needs treatment.
Okay. All right. This is what the court is. Is there anything else for me to say? All right. This is what the.
Here's the ruling. Guilty, 6 years in the therapeutic community, TC. No contact with Robert. Credit for time served, and the judge retains jurisdiction. That last piece is huge. It sets up shock probation, a mechanism where, after up to 180 days in prison, the defense can ask the judge to suspend the remainder and place her on probation if she's clean, compliant, and engaged in programs. This turns prison into a structured reset, not a dead end. The judge even outlines the roadmap: sign up for parenting, anger management, TC, stay infraction-free, and come back with positive reports. Viewer takeaway: accountability now can unlock supervision later. Would you take 6 months of hard structure for a shot at probation?
Court is going to do. I see that she hasn't been to prison before. I'm going to find her guilty, sentence her to 6 years in the prison, the therapeutic community. There's to be no contact with Robert Marble. Give her credit for any time served, and I'll retain jurisdiction.
Okay.
And you can explain to her what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I'll tell them. So here's the thing. When I say that I'm going to retain jurisdiction, what that means is they're going to take you to prison. If you're following the rules at the prison, if you're working on yourself, because they have programs at the prison, your attorney can file a motion. It's called Shock Probation. Back when I was growing up, they would have scared straight programs. So Shock Probation is sort of a scared straight program. So hopefully when you go to prison, you will clear your mind.
Yes.
The drug use or the addiction that you have, the craving that you have will be lifted. And if you are doing what you're supposed to do at the prison, if there are no bad reports at the prison, when your attorney comes back for a request for shock probation, I will strongly consider it. So while you're at the prison, you have 180 days. That's when he needs to bring it back before me before that time period. So you're going to do 6 months. And if you are doing well, if there are no write-ups against you, then the court will strongly consider giving you probation. You understand?
Yes, ma'am.
So, well, I mean, these are going to be choices that you make. It's going to be completely up to you whether or not I strongly consider giving you probation. Your attorney will explain it to you further, but any programs that they have at the prison, like the therapeutic community, to address your issue, you need to take it. I know they have parenting classes at the jail. I don't know how long the transfer will be, but you need to take advantage of that. When you see people come before me and they've gone to anger management class, they've done parenting classes, they've availed themselves of everything at the jail and everything at the prison, that is what you need to do. You need to immediately sign up for it. If for some reason there's overcrowding and they don't give it to you, it would be better for you to have signed up for it than to just throw up your hands and say, I'm not trying. Do you understand?
Yes.
And next time, if you have a case before any judge, don't use before coming to court. You understand? But I do appreciate your honesty, but you're going to have to get your life in order. Otherwise, children is going to be without their mom. You understand? All right. Good luck to you. You're welcome.
Thank you.
Okay, so shock probation, it is like a straight program. Basically, they go to prison. Hopefully they'll view everything. They won't want to go back. They'll get a clear head about everything. But if she does everything, more likely than not, I'm going to grant her a motion for shock probation, and I'll have her probably see if felony drug court will take her, or if Esperanza will take her some inpatient treatment. Okay.
Professional summary. The defendant pled no contest to possession in the 4 to 200 grams range. Key aggravators were the lab-confirmed weight, scale, and baggies, and fresh drug use before sentencing. The judge rejected outpatient as unrealistic, imposed 6 years, TC barred contact with a co-involved person, and critically retained jurisdiction to allow shock probation. Within 180 days, if she excels in custody programs and keeps a clean record. Big picture, the court balanced community safety with rehabilitation, using custody to stabilize addiction while leaving a probation off-ramp for genuine progress. For you, was this the right blend of accountability and treatment? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.